Right, a common question people ask me is, do I need a will? In giving that advice, I always say to them, it's very important that you do have a will, because a will is a legal contract between you, the will maker, and the executor. That the executor is the person to whom you trust to carry out your wishes when you leave this world. The executor can be a beneficiary. That's a common question I'm asked. And the executor is normally the spouse or a member of the family. The next requirement of a will is that they need property. Now, property can be described as real property, which is land, and personal property, which is everything other than land. You can make specific bequests of your property. For example, you give your jewellery to your eldest daughter, you give your car to your son, you give your tools of trade to your other son. A will can be anything you want to put in it, as long as it's legal. It's important that the will is kept as simple, and that it is done with the advice of a legal practitioner. There are certain formal requirements in making a will. It needs to be in writing, and it needs to be dated and signed at the foot of the will and witnessed by two persons who are over the age of 18. It's important that beneficiaries or spouses of beneficiaries are not witnesses to the will, because that could preclude the bequest going to that beneficiary. The witnesses need to be present at the same time, and as I said, they need to be over the age of 18. So they are the formal requirements of a will.